Good afternoon, everyone, and welcome to today's webinar on CCPA enforcement. My name is Josh Stevens. I'll be one of your presenters. Before we get started, I do have a few quick housekeeping items. First is we have received a few pre-submitted questions that we will answer at the end of today's presentation, but because this is one of our Thirsty for Knowledge Thursday series presentations that last only 30 minutes, we probably won't have time to get to any additional questions. However, if you do have questions, please go ahead, submit them through the chat box, through the questions tool, and then we'll follow up with you afterwards with responses to your questions. Another thing I just want to let you know is that at the end of this webinar, because everybody asked if they can get the materials or maybe listen to the webinar later, we will be sending an email out that will have instructions for how you can access the webinar afterwards. The webinar will be posted on our website, as well as a back catalog of prior webinars we've done. So if you're interested, if this is your first webinar, or maybe you've missed some of our webinars in the past, if you're interested in listening to some of the older ones, those will be available on our website. And so with that, as I mentioned, my name is Josh Stevens. I am a senior attorney here at McMurray & Schuster, where I am in our compliance department, focusing my practice on privacy, data security, telemarketing, and marketing and advertising compliance in general. And joining me today is my colleague, Chad. Chad, why don't you go ahead and introduce yourself? And Chad may be muted.
Oh, I was, Josh. Thank you. Good catch. Good to see everyone here. Thank you for your time. My name is Chad Blackham. I'm an associate attorney with McMurray & Schuster. I'm primarily involved in class action litigation defense, but I also help out our privacy compliance group quite a bit.
Great. And just as always, today's presentation is informational. It's intended to be kind of a high level. Everybody's factual circumstances are different, and especially in privacy law, the facts really matter. So don't act on anything that you're hearing today in today's presentation without talking to your counsel first, because your facts may change what you need to do compared to what we're talking about. During today's presentation, we're going to give a little bit of background and highlight some key points from the California Consumer Privacy Act, the CCPA, which went into effect on January 1st and enforcement started July 1st. We're going to talk about the final regulations that were issued in June, right before the July 1st deadline, and a few things that they may be changed or that we want to highlight for you out of those. We'll talk about what the enforcement landscape is looking like. And then we're going to look to the future and talk about the California Privacy Rights Act, a ballot initiative that's going to be on the ballot for Californians in November, as well as what to expect from other states at the federal level. And then, as I mentioned before, we do have a couple pre-submitted questions that we'll answer at the end. If by some chance we do have some additional time, we might take some of the questions that are submitted during the presentation. But again, if you do submit a question during the presentation, we can't get to it, we will respond to you later. And with that, let me turn it over to Chad to walk us through the CCPA with a few key highlights.
All right. Thank you very much, Josh. So we're going to start off with personal information, right? Now, as Josh noted, privacy law is very fact-specific. It's very broad, but one of the constants and one of the biggest pieces of the California Consumer Privacy Act is what is personal information. So this is the type of information that's going to be protected by the Act. It's going to include garden variety personal information such as first name, last name, address, social security number, including unique and online identifiers. Now this might be a account name or a password or a special PIN you need to get into an account. And of course, you have some other categories that you might expect, such as IP addresses, browsing history, geolocation, really anything that can be used to match a user to their specific privacy information or their browsing habits. This is going to exclude, however, de-identified or aggregate data. And for those who are curious about what that is, it's essentially masking information so that the specific identifiers cannot be matched up with the individual. Think survey information, for example. It's broad, it tells you information, provides the data, but you have no way of actually matching that up to an individual. So that de-identified and aggregate data is not going to be included in the otherwise relatively broad definition of personal information under the California Privacy Act. So we're going to talk about some key points in the Act, the actual statutory text of it before we get into the final regulations. And this was always fascinating to me. If you're an attentive listener, you might have heard Josh say that the Act went into effect January 1st, but the regulations actually didn't come out until beginning of June. You heard that correctly, and for the first few months, the Act people and those who are required, and businesses required to comply with the Privacy Act, we're kind of left a little bit in the dark with these very broad key points only. So we'll talk about the specific final regulations in a bit, but right now let's talk about what the bill itself requires. So point of collect, and for those who are also very into international privacy law, I'm sure you'll see a lot of parallels with the European GDPR here. So the first one here, point of collection disclosures. This is essentially saying that when you collect information from someone, you have to tell them the purposes, if they're going to share it, the categories of information, just provide some a little bit of elucidation on that. And this ties into the privacy policies, right? So the CCPA requires businesses to have a privacy policy, and this policy has to have disclosures. So what we've been seeing a lot of is the point of collection disclosure will say, we retain the right and ability to use your information for every purpose in our privacy policy, and then the privacy policy itself will disclose the categories and purposes of that information. So businesses also have to do post-collection disclosures, not just point of collection. So upon request, they have to tell the consumer all about the PI that they've collected, sold, or shared. And you know, some of the early reports we're seeing about this stuff from companies like Facebook, it's absolutely astounding how much information the categories are gathered and to how many third-party marketers are sold. If you get weird telemarketing calls or weird emails from third parties, it's a good chance it was because someone sold them your data. And the final point here, consumer opt-outs. This one's near and dear to my heart because I've got an Apple email address with over 1,000 pieces of junk email in it, and it's more of a hassle to go through and get rid of them than just to leave them. So what this requires is consumers have to have the ability to opt out of having their PI sold to third parties. And this includes a do not sell info link. Now, the interesting thing about the do not sell info link is you may be curious what type of form it has to take or what it must look like. We'll get into that a bit with the final regulations, which talk more about it. All right, so a couple more key points. First, we have children opt-ins. You have to obtain consent to sell PI related to children under the age of 16, which is a little bit higher than the 13 at the federal level. And then we have consumer deletion requests. Subject to certain exemptions, you have to honor requests to delete consumers' PI. And finally, we have prohibitions. You cannot discriminate against consumers on the basis of them not wanting to exercise or wanting to exercise privacy rights, which I think is a very good idea.
Yeah, thank you, Chad. And so, as Chad mentioned, you know, we've got these high points from the statute, but how you actually go about implementing those was really kind of a gray area. It's frankly, even after the final regs, it still kind of is. But we did get at least a little more guidance through the final regulations. So the first has to do with identity verification. So under the CCPA, as Chad mentioned, consumers have the right to obtain information about the types of information that you're collecting about them. They also have the right to access the personal information that you have stored about them, and they have the right to request that you delete information that you have on file. But the statute requires that before you can honor those, you have to verify the consumer's identity. And that's pretty much all it said. So what the regulations did is they explained there are a couple of ways you could do this. So for example, if you have consumers have a password protected account. So for example, I went through this process with Starbucks just out of curiosity. So I have a Starbucks account and I was able to log in, and they used that login process as a way to validate who I was. If you're dealing with a consumer who doesn't have that type of password protected account, then you need to go through a verification process that has 2 tiers depending on the type of information that you're going to be disclosing in an access request, or the risk of harm to the consumer if you inadvertently delete their information in a deletion request. So if there is a lower risk of harm to the consumer, or you're just going to be disclosing, for example, the categories of personal information that you have about someone, then you only would need to verify them to a reasonable degree of certainty, which essentially means that you need to ask them at least 2 challenge questions that only they are likely to know. So what we've seen a number of our clients do, for example, is something like, on your order dated January 31st, 2020, what products did you buy, right? Or when you placed an order with us on such and such date, what were the last 3 digits of the credit card used? Something like that, that again, probably the consumer is the only person who's going to know that. For an access request where you're actually turning over someone's specific personal information, or if you delete their information, there's a high risk of harm, then we go to a higher standard called a reasonably high degree of certainty. And in this scenario, you not only ask 3 challenge questions, so similar to the reasonable degree of certainty, but adding a third question, you also need to get a signed declaration from them under penalty of perjury. And one of the things that some of our clients ran into with this initially was based on the very first draft of the regulations. It had this requirement. And so we had suggested to some people, well, why don't you include a notary blocks? That way you know for certain that this person is who they say they are, right? Because the notary is checking their ID. And then in the final regulations, what we've now learned is they don't want you to do that. Notary requirements are actually prohibited unless the business is willing to reimburse the consumer for the cost of the notary. So in my opinion, I think it weakens the value of that signed identity verification declaration because you're not getting that independent notary to check it out. But you know, it is what it is, and businesses can make decisions as to whether it's important to them to really verify that identity. As I mentioned, you do have these rights that the consumer can exercise. The business has certain times in which to respond. And so the final regulations clarified that for a right to know or access request or a deletion request, you have 10 business days to confirm receipt of that request. And then you have 45 calendar days in which to respond fully to that request, subject to one additional 45-day extension that you can exercise with notice and explanation to the consumer. For a do not sell or opt-out request, those just have to be honored within 15 business days. So there was some confusion initially over the time periods for response, whether they were calendar days or business days, and the final regulations clarified that for us. As Chad mentioned, consumers get the right to opt out of the sale of their information. And so the regulations have explained that notice of the right to opt out needs to be linked on the homepage of the website or in the mobile app, and on any page on which personal information is collected. So what most of our clients are doing is they're putting a hyperlink to it in the footer or in the wrapper, right, of the website, and in like the settings menu in a mobile app, so that it's easy for a consumer to get to. That link has to be titled either "Do not sell my personal information" or "Do not sell my info." And when the consumer clicks that, it's supposed to take them to a web page that explains, that has a notice explaining their right to opt out, how to exercise it, and then allows them to submit that do not sell request through that web page. So for some businesses, I know that the do not sell web page requirement was a bit of an annoyance because they were hoping to be able to do it maybe just through email or through a customer service phone line. But we do have to have this actual web form that the person can complete. Now, one of the things that has been up for debate is, what do we do when there are privacy settings in somebody's browser or on their device? And what the final regulations have clarified is that businesses have to honor browser plugins or settings or device settings that communicate the consumer's choice to opt out. We've had a lot of questions from clients about how this plays with California's do not track requirement. Those are two completely different things. California's do not track law relates to signals communicating that a consumer does not want to be tracked across websites or devices. What this is about is communicating that the consumer does not want their information to be sold. At this point in time, we are not aware of any of the major browsers having built this functionality in, or any of the major device manufacturers having built this in. But I would not expect that to be the status quo for very long. We know that Apple, for example, in their most recent WWDC presentation, really highlighted privacy and how they're building in additional privacy tools in Safari and on their devices. Now that these final regulations are out, I would expect sometime in the next maybe 12 to 18 months to start seeing these types of settings appearing. So you want to have your IT folks paying very close attention to what's going on out there in the tech world. Be watchful for these types of settings, and then figure out how, from a technical perspective, you're going to be able to receive those signals and honor them. You can also deny requests to delete under certain circumstances. The final regulations did validate that. But if you do that, you've got to inform the consumer. You got to explain to them why. You got to explain what you kept. And you can only use the information you kept for the reasons that you explained to the consumer. You also, if you do just a full denial, you've got to ask the consumer if they'd like to opt out of the sale of their personal information. And two more real quick, accessibility requirements. Many of you might be familiar with the Web Content Accessibility Guidelines produced by the World Wide Web Consortium. WCAG 2.1 is the most recent standard. The regulations have codified that standard has to be used to make sure that your website and all of these disclosures and tools that are required for consumers to exercise their rights comply with those web accessibility guidelines. And lastly, if any of you on the call are from really large consumers, or really large businesses rather, who collect, receive, sell, or share the personal information of 10 million or more consumers, or expect to this year, and remember, consumers for purposes of CCPA is just people in California, there are certain detailed records that you need to keep, and you need to prepare to publish a certain publish reports based on those records come next July. So this isn't going to affect a ton of companies because, again, 10 million Californians, you'd have to be harvesting a lot of data to hit that threshold. But if you are a larger participant, you need to keep this in mind. And Chad, now that we know what it seems we've got to comply with, what's the enforcement landscape looking like?
Awesome. Thanks, Josh. I love talking about enforcement because this is what you guys are concerned with. You want to know, what the penalties are. So the CCPA is interesting. There is an action by the Attorney General, and then there's a limited private right of action for consumers. So for the Attorney General, So for the Attorney General violations, unintentional violations is going to get you $2,500 per violation. That's pretty hefty, especially since it's per violation. Now, if it's intentional, which could even be demonstrated by willfulness, not intending to necessarily break the law, but you know that what you're doing is improper, that's $7,500 per violation. Extremely hefty. So transferring to the limited private right of action by consumers, it's not quite as hefty, but you're going to see why it adds up in a similar way. So if a consumer's PI is stolen, either non-redacted, either unencrypted, or if it is encrypted in a way that would allow it to be de-encrypted, consumers can recover between $100 and $750 for each such incident. Now, when you're looking at a class action litigation that can involve, potentially tens to hundreds of thousands to even millions of consumers in the case of extremely large retailers like, Walmart or Amazon, these fines are going to be extraordinary. And we're going to talk about it shortly, but we're just starting to see them get litigated. And it's going to be very interesting to see how courts handle them. So let's talk about a couple specific cases. So the first one here, and you're going to notice all these cases are fairly recent, given the fact that the CCPA only went into effect this year. So in Chef v. Ring, and for those who aren't familiar, Ring is a smart home company. They do cameras, doorbells, I believe a little security protection equipment. But Mr. Chef brought a suit against them for failure to institute reasonable security measures, lack of notice of collection, and for failure to provide consumers notice of the right to opt out of the sale of their PI. Now, for those who are paying attention to Josh's final regulations, it's kind of a laundry list of some of the things you should not be doing. And what's also interesting here is, and we're going to see this in the next case as well, is the plaintiff is alleging violations of unfair competition laws. What's really critical about this is these plaintiffs are using the CCPA as a type of predicate offense to try and shoehorn unfair competition claims where they might not otherwise exist. I personally have a feeling courts will not be too receptive to it, but I also think that given the amount of litigation that's going to occur, we might see some circuit splits on the, not circuit splits, but splits within the California circuit courts and perhaps even district courts with regards to this type of enforcement. And so the second case we're going to be discussing is Henry v. Zoom. As I'm sure many on the call are aware, Zoom has had some security issues lately. And the plaintiff in this case recognized that and brought suit. Interestingly enough, the first one here, unauthorized disclosure of consumer data. That goes to a couple points. The first is Zoom must not have been providing the proper point of collection notice disclosure. Otherwise, such disclosure wouldn't be unauthorized. But I was reading through the plaintiff's complaint, and apparently Zoom has heavy involvement with the Chinese government. So the client here is also trying to introduce a type of public policy rationale based on the unauthorized disclosure of consumer data, such that they're arguing this disclosure is harming me in a way that would not have otherwise if I knew where your data centers were or I knew who you were interacting with. Similar to the Ring case, we are also getting violations of unfair competition laws. Once again, the plaintiff here is trying to use these as a type of predicate offense to shoehorn in something else under the CCPA. And if you're really attentive, you'll know this is in a different district than the previous case. So this might be a good test example to see if any discrepancies or divergences occur. But again, these are some of the very first cases we're seeing. And it's unclear exactly how the courts will evaluate fines or even enforcement to that extent. But I do think that since Ring and Zoom are kind of larger, more well-known companies with a bit of clout, I think these would be good case examples. And I think the courts may try and make a message out of these cases, similar to the recent Facebook FTC interaction. And with that, I think, sorry, go ahead, Josh.
Yeah, so Chad, just one additional thing that I wanted to comment, because there have been a couple, I think there are maybe two more cases, but besides these two, that are starting with the consumer enforcement. And it's interesting to see how these are being pled, because some of the plaintiffs are framing it as, like you mentioned, Chad, there was a violation of the CCPA, which serves as a predicate act for a deceptive or unfair practice under the unfair competition law. And so I should be able to get, you know, a verdict under the unfair competition law and you know, get a class action that way. That's how some of these that's how these two have been pled. It's kind of interesting. But the way we've seen in a couple other cases is what they're saying is you committed a violation of the CCPA by not having a fully adequate privacy policy, let's say. Therefore, everything you did with my data that wasn't fully disclosed in that privacy policy was unauthorized and was therefore a data breach. And so it's going to be interesting to see, you know, if one or both of those or neither, you know, get some legs under them in the courts.
Now, on a personal level, Josh, what's your thought? Do you think they will be? I'm thinking no, but
I have a hard time seeing it on the unfair competition law, but then again, California often surprises me. Just because there is some language in the CCPA statute that explicitly says that there is not an intent to create a private right of action outside of the data breach context. So I have a hard time seeing that one working. I think the one that might have a better shot is the one about any unauthorized, quote unquote, unauthorized use being a data breach. I think that one's going to be interesting. So with
gotcha.
that, and here we're running up on time, so just real quickly, where are we heading? First is coming up in November, we have a ballot initiative in California, sometimes referred to as CCPA 2.0, the California Privacy Rights Act, which if it passes, and let's be honest, it's going to pass, it would take effect January 1st, 2023 with a look back period to January 1, 2022. So really we would be encouraging people try to get in compliance by January 1, 2022. Just a couple highlights here. First, it creates a category of sensitive personal information that gets increased protection. It's gonna be things like health information, financial information, social security numbers, government ID numbers. Secondly, it gives consumers a right to data minimization. So you're going to need to begin disclosing retention periods for each type of data and honoring those. We see many clients that really, they just hang on to everything forever. It's not really going to be viable anymore once CPRA passes. Consumers also get a right to data correction. So they can come to you and say, I think you've got information about me and it's incorrect. Here's what it should be. Third, service providers, so vendors of businesses that are controlling the data. So if you're familiar with GDPR, with controllers and processors, service providers are like a processor, are actually going to now have an affirmative obligation to assist businesses with compliance. Fourthly, this one's actually pretty good. One of the three ways you can become a business under the law is going to get a little harder to meet. The threshold is going to be increased from 50,000 California consumers per year to 100,000. Now, the Rights Act, it does a number of other things. I just wanted to highlight these for you. One other one that a lot of people have been commenting about is it would actually create a dedicated privacy enforcement agency in California. Right now, the Attorney General is the one in charge of enforcement. This would create a dedicated agency. Looking more broadly, New York recently implemented the SHIELD Act back in March, which requires businesses to implement some heightened data protection measures. There are some exemptions to it. I'm not going to get into the details, but the point is if you have data for New York consumers, definitely check out the SHIELD Act and make sure that you're meeting its standards. The state of Washington had a privacy bill that came a hair away from passing this spring. It was exceptionally close. At the last minute, there was a small discrepancy between two versions related to a private right of action. We fully suspect that is going to get hashed out over the course of this year, and the bill will pass next spring. So be on the lookout for it. It's more like GDPR than CCPA. So businesses that have been complying with CCPA may have to make some changes to comply with it. And then at the federal level, there are multiple bills that have been proposed in the Senate and the House. Kind of the trends of issues that we're seeing, though, is that bills proposed by Republicans tend to not include private rights of action or preempt state laws. Bills proposed by Democrats tend to include a private right of action and do not preempt state laws. So these seem to be the sticking points at the federal level. I suspect we're going to see some movement coming along soon, but we'll see after the election. I doubt anything significant is going to happen before November. And with that, I do want to get real quickly to our 3 pre-submitted questions. I know we're a smidge over here, but I do want to just touch on these. And again, if you have to hop off, you can check out online afterwards the recording to catch this last couple minutes. First question was there any discussion about individuals using CCPA to their financial benefit in the regulations? No, that's not something that was really addressed. I think, like we talked about, you're going to see some class action litigation. You're seeing the creative ways that plaintiffs are trying to use CCPA to create class actions. We'll just have to see how that goes. It has the possibility of becoming like another TCPA, Telephone Consumer Protection Act, but we'll have to see. The second question we received was, how does this legislation affect political calling programs? One of the things that's important to note is the definition of a business requires that it be for profit, and the CCPA only applies to businesses and their service providers. So if you're doing work on behalf of, or if your organization is a nonprofit, such as a charity or a political campaign, you're not going to be subject to the CCPA. But at least with regard to that work. If you're a vendor and you're doing work for a bunch of other companies, you might be, but at least with that campaign, you wouldn't be. And then the last question was, how can we collect and use email addresses for purposes of marketing when submitted by our customers for other reasons? And so unlike GDPR, which requires that you get affirmative consent to process someone's personal data for marketing, under CCPA, as long as that use is properly disclosed in your privacy policy, you can use the information that way. So if someone gives you their email address because they're placing an order with you, you can use that for marketing if the privacy policy discloses it, and if you're doing it in compliance with CAN-SPAM. So remember, the United States works on an opt-out regime under CAN-SPAM for marketing emails. So as long as you're complying with CAN-SPAM's requirements, you should be okay. As I mentioned, facts in the privacy world really matter, but this is an area where you probably will be okay, but definitely check with your counsel. And with that, I'd like to thank everyone for joining us today. We will be having our next webinar in August. It's going to focus on protecting different forms of intellectual property. More details to follow, including the date and time. And with that, thank you all and have a great rest of your day.